Hi, my name is Chris Nolan. I'm a barrister at Queen Victoria Chambers in Sydney. This video is called How to Apply for Bail, and it's designed to assist legal practitioners in the state of New South Wales. There's an accompanying paper, and you'll find the link to that paper in the notes below. I'm going to start by telling you what not to say. I've been a barrister for a long time. I've had a lot of bail applications, and what new practitioners tend to do is they tend to stand up and declare that their client denies the allegation and they're entitled to the presumption of innocence. Now, this is entirely correct, but it's also totally irrelevant. And if you say this, a magistrate is very likely to look at you and say that there are hundreds of people on remand in civil water. All of them have declared their innocence, and all of them are also entitled to the presumption of innocence as a matter of law. So this is not a fact that is unique to your case or particular to your client. So what do you want me to do with this submission? And that is normally met with a blank stare from the practitioner. So that's what not to say. So this is what you should say. There are 4 bail concerns in Section 17 of the Bail Act, and every lawyer should know them by heart. The first concern is that the accused person will fail to appear at any proceedings for the offence. The second concern is that the accused person will commit serious offences while on bail. The third concern is that the accused person might endanger the safety of victims, individuals, or the community. And the fourth bail concern is that the accused person, if granted bail, might interfere with witnesses or evidence. The test that the court applies is called the unacceptable risk test, and it has 2 steps. In the first step, the court asks whether there is an unacceptable risk with respect to one or more of the bail concerns. If the answer to that is yes, then the court moves to step 2 and asks, can that unacceptable risk be mitigated by imposing bail conditions? Now, bail conditions are not designed to be punitive. They are designed to address the bail concerns. So there needs to be a logical connection between any bail condition and one of the bail concerns. So, for example, if your client were a foreign national who might flee the country, then it would be appropriate to have a condition that he surrender his passport and not approach any points of departure, because such a condition directly relates to the bail concern. If you have a prosecutor who is attempting to impose conditions simply to be vexatious or punitive, your job is to stand up and say to the court and to the prosecutor, what is the connection, which bail concern does this condition address, and what's the rational connection to it? And that brings us to Section 18 of the Bail Act. Section 18 is a list of factors that the court must take into account when considering a bail application. So when you are taking instructions from your client, you should print out Section 18 and have it in front of you and go through that list and ask your client about every single factor in that list so that you can then convey that information to the magistrate. Okay, so you've taken instructions from your client. You've gone through all the factors in Section 18 and you've turned your mind to which of the 4 bail concerns might be of concern to the court and how that concern might be addressed by bail conditions. So you're ready to make your submissions. I'm going to make some sample submissions right now. This is a made-up case. It's not a real client, but you will notice that I am going through all the factors in Section 18 in the order in which they appear in Section 18. So the submissions would go like this. May it please the court, I make a release application under Section 49 of the Bail Act. My client comes before the court charged with assault. He's a 25-year-old carpenter. He had steady employment and has lived at the same address for the past 3 years. I submit the allegation against my client falls at the lower end of the scale of seriousness. The allegation is not of a sexual nature, no weapon was used, and there was no suggestion that the offending was motivated by racial or sexual prejudice. Despite the police assertion of a strong case, my client instructs me that he intends to contest the charge vigorously. My client has a checkered past, but his criminal antecedents include only minor offences, and the last offending was over 2 years ago. The offending was limited to drug possession and larceny, and he has no history of violence. He has been released on bail previously and has always complied with his bail conditions and never failed to appear. He was placed on a 12-month bond for his most recent offending and complied with the conditions. I asked the court to take into account the current delays in obtaining a hearing date. My client is likely to spend at least 3 months in custody if bail is refused. Even if convicted, he is unlikely to receive a custodial sentence of that length. I also asked the court to take into consideration my client's special vulnerability and needs as an Aborigine with a cognitive impairment. Bail will allow my client to continue with his employment and allow him to obtain legal advice and prepare his defence. The complainant in the matter is a stranger to the accused, and they are unlikely to cross paths again before the hearing. However, any concern the court might have can be mitigated with conditions prohibiting contact between the accused and any witnesses in the matter. I submit that there is no unacceptable risk regarding the bail concerns that cannot be mitigated by the imposition of bail conditions. Okay, so you've made your submissions and you've answered any questions that the magistrate might have. At that point, the magistrate will make their decision, and they are required by Section 38 of the Bail Act to immediately record the reasons for their decision. And they do so on a particular form which looks like this. Yay! It's entitled Summary of Reasons for Bail Decision of the Court, and it lists all of the factors regarding the bail concerns, and the magistrate simply ticks the boxes. So this form is of great assistance to you when you are making a bail application, because if you and he have the same form in front of you, you can address all of these factors in exactly the order that they appear on the form, and the magistrate can simply tick the relevant boxes as they go. So page 1 is the section of bail concerns. If bail is granted, they flip over to page 2, which is a list of conditions, and they simply tick the boxes. Is there a residence requirement? Is there reporting? Is there a curfew? Do they need to surrender their passport? They simply tick the boxes, and then they sign at the bottom, and that's the record that they put on the file. I recommend that you download this form and print it out, because it will be of great assistance. And that brings us to the final part of the video, which is Section 22, capital B of the Bail Act. This is a new provision, and it provides that where an offender will be sentenced to full-time custody, the court must refuse bail unless there are special or exceptional circumstances. So prior to June of this year, it was a regular test applied to all accused persons, and even after they were convicted, that the court would consider the 4 bail concerns, and if they said it wasn't an unacceptable risk that they would reoffend or interfere with witnesses or flee the jurisdiction, they would be given bail to get their affairs in order. If they own a house, they might want to get a tenant in to rent it. If they own a car, they want to sell it. They want to get there. If they own a business, they might need to sell that or get a manager in. And they would want to see their families before they went inside. They might need some medical treatment. There's lots of reasons why bail should be granted, because at the end of the day, if you're going to hang someone, you can hang them tomorrow just as well as today. It's a very difficult situation to put a judicial officer in, because they're being asked to speculate, to have an estimate as to what's going to happen at a sentencing hearing, and to do so without any of the subjective material that will be produced at that sentencing material. So in a case that is borderline, where an offender could get full-time custody, but just as likely get an intensive corrections order, which way are they going to fall? That's the judgment of Solomon. Now, on the 12th of August, the Court of Criminal Appeal handed down a judgment in the case of Van Gestel, and that was a joint judgment of all 3 justices on the Court of Criminal Appeal. And the key paragraph is paragraph 44. And in paragraph 44, the court attempted to construe the word will in Section 22, capital B. What does it mean to say an offender will be sentenced to full-time custody? And they've come up with the phrase that the court has to ask itself, is it, quote, realistically inevitable that the offender will be sentenced to full-time custody? If the answer is yes, then you go move to step 2 and you consider whether there are special or exceptional circumstances, and that will depend on the facts of your particular case. In the case of Mr. Van Gestel, he was convicted, found guilty of sex offences against children, and he was definitely going to be sentenced to full-time custody. There was no doubt. So he was refused bail, and the Court of Appeal approved that decision. Thank you for your attention.